Good morning, Mr. Chairman and members of the committee. My name is Carrie Silverman. I'm a partner at the law firm Shook, Hardy & Bacon and an adjunct professor at George Washington University Law School. And I was asked to testify today on behalf of the Pennsylvania Insurance Federation and the Pennsylvania Catholic Conference on the reviver provision.
And my name is Stephen L. McKochik. I'm an emeritus professor of constitutional law at Temple Law School. And I was also asked to testify today on behalf of the Pennsylvania Catholic Conference.
Okay. All right. Thank you very much both for being here, and we'd like to hear your testimony.
Thank you, Mr. Chairman, members of the committee. I appreciate you spending this time today looking at this issue so very closely on the constitutionality of the reviver provision. I have gone and I've testified before state legislatures, several of them across the country, considering bills similar to that which you're considering today. So I've looked at this issue for several years now, and I was asked to look at it specifically on the constitutionality under Pennsylvania law. And I look very closely at the Pennsylvania case law that you've already been discussing today. But I hope what I'll do today is put it maybe in a slightly different framework for you that you might find helpful in understanding it and looking at this analysis. What I found was that Pennsylvania constitutional law, it's consistent with what others have said, is remarkably consistent. There's no real conflicting opinions. There's no gray area. There's no open question that I found. I mean, each and every case that we've been discussing today seems to boil down to one very basic principle, and that's that the remedies clause does not allow the legislature to retroactively eliminate an affirmative defense in the same way that the legislature cannot retroactively take away a plaintiff's cause of action. In either case, there is a vested right that cannot be eliminated. And once the period for bringing a claim expires, Pennsylvania courts have said over and over again that no legislative action can revive that claim. My prepared testimony that I submitted goes through this chronologically and with a lot of detail. What I'd like to do is just give a kind of framework, comparison of some of the cases that I think will show how the remedies clause both is important to plaintiffs and is important to defendants. And the first, what the case law shows is that the legislature cannot retroactively take away a defense, just as it cannot retroactively take away the plaintiff's claim. And this goes back to the Lewis case that we've been discussing, Lewis versus Pennsylvania Railroad, back in 1908, a long time ago, but still being cited frequently today in Pennsylvania case law. And there was a widow of a railroad worker who sued the railroad for negligence after he died in a work-related accident. The law at the time provided that the railroad had a complete defense. It was immune from liability from these types of lawsuits. The legislature then felt that that was unfair, and it passed a law retroactively subjecting the railroad to liability. And the Pennsylvania Supreme Court said no. It said if the plaintiff may assert that he or she has a claim, a vested right to a claim, on what possible ground can it be held that the defendant has no vested right to an exemption or to a defense? And it found that there was no distinction. The court continues to apply that principle today. I mean, those of you who have served in the legislature for many years may remember the enactment of a law that retroactively provided immunity from asbestos claims to Pennsylvania businesses whose liability was due solely to merging with a company that produced asbestos many years ago. That was in Aropoli versus ACNS in 2004, when the Pennsylvania Supreme Court said that that law was unconstitutional when applied to retroactively because it extinguished accrued claims. And indeed, a district court had dismissed hundreds of claims under that law. And that's how this principle of the remedies clause protects plaintiffs. But the flip side of the coin is that it also does not allow the legislature to extinguish in the same way a vested defense, as the court recognized in extensively quoting from the Lewis, the railroad case, in that Aropoli case in 2004. Second, the legislature may retroactively alter a claim or defense so long as it does not extinguish it. And you can see this in the Pennsylvania Supreme Court's decision in Bible in 1997, where the court said that the legislature can retroactively change the amount recoverable on a worker's compensation claim for hearing loss. That law did not take away a plaintiff's vested right to file a claim for hearing loss. the court found that there was no vested right to a specific amount of compensation there. So it distinguished a claim from just merely tweaking, basically, a claim and what you could recover on a claim. And you can see that principle applied more recently in Conandaris in 2008 by the Pennsylvania Supreme Court, where the court said that the legislature could retroactively require delinquent taxpayers to pay a school district's attorney's fees. There, the defendants there claimed that the legislature took away a so-called right not to pay attorney's fees. But that, the court found, was not an affirmative defense. It distinguished that was not a vested right. So what Bible and Conandaris show us is that the legislature can retroactively make minor modifications to how a cause of action is brought or what the remedy is. But what it cannot do is eliminate a claim or a defense. And third, and this is an application of the first 2 points, the legislature cannot extend the statute of limitations to revive time-barred claims, just as it cannot reduce a statute of limitations to extinguish a plaintiff's ability to bring an accrued claim. And worded another way, the legislature can extend a statute of limitations for claims that have not yet expired, and it can reduce a statute of limitations so long as it does not effectively bar an accrued claim. And we can see this principle going way back to 1862 in Baggs' appeal, where the Pennsylvania Supreme Court said that once the time to file a claim against an estate had passed, the Remedies Clause didn't allow the legislature to pass a law requiring the court to consider a claim of a family member who was located in a remote part of the state, didn't know of the death, to then file a claim after the period had expired. But let's flash forward to a situation much closer to what we're looking at today. Pennsylvania law traditionally did not toll the statute of limitations when a minor was harmed. In 1984, the legislature enacted a tolling provision, which stopped the clock until a child reached 18, after which they could bring a suit in their own name. Following enactment, there were a flurry of lawsuits by adults seeking to recover for injuries that occurred during their childhood. There was a sidewalk fall, a medical malpractice case for birth-related injuries, an action against a landlord for a burned hand in the house, product liability actions against manufacturers. In each case, the superior courts, applying Lewis, found that the 1984 tolling provision could not revive a time-barred claim. And the most frequently cited of those cases is the Maycock v. Gravely Corporation, 1986 case, which involved a person who had lost a leg as a child as a result of a lawnmower accident. There, a unanimous panel of the Superior Court recognized that while the tolling legislation back in '84 was silent as to whether it applied retroactively, and I quote, "Had the legislature made any such attempt, there is authority to indicate it would be unconstitutional." The same principle that restricts this body's ability to retroactively extend a statute of limitations limits the ability to reduce a statute of limitations. Imagine, for example, that a person who's hurt contacts a lawyer, and that lawyer is under the impression that a 2-year statute of limitations for personal injury claims applies. And that lawyer investigates the case and hires an expert witness and drafts a complaint, and is on the eve of filing the lawsuit when the legislature acts and changes the statute of limitations and makes it now 1 year. It was 2 years, now it's 1 year. Is that constitutional? Absolutely not under the case law. The legislature would have extinguished an accrued cause of action. And what the Pennsylvania Commonwealth Court found in McDonald v. Redevelopment Authority, and this is 2008, it was mentioned earlier, is that the legislature can only reduce a statute of limitations retroactively if it provides those who have accrued claims an adequate time to bring them. Otherwise, it would be eliminating a vested right. So the flip side is that the Remedies Clause does not permit the legislature to retroactively expand a statute of limitations if it would revive an already expired claim, eliminating a vested defense. Both are vested rights, and neither can be extinguished by legislation. So there's been a lot of talk about where does Pennsylvania fall nationally. And state constitutions, they vary, and judicial interpretation of similar and even identical provisions can vary from state to state, as we've heard. Now, that said, a majority of states that have considered whether their legislature can revive time-barred claims have said no, whether they do so under a similar remedies clause, a specific provision prohibiting retroactive legislation, which many states have, due process, or other grounds. The weight of authority, and it's been recognized by several state Supreme Courts, which are cited in my testimony, is that this cannot be done constitutionally. Now, in some states, it's about a third by my count and by the count of others, follow the federal approach, and the federal approach is more lenient, and it doesn't have the protection that you have here. The federal approach generally allows retroactive legislation. And the U.S. Constitution has an ex post facto clause which prohibits retroactively changing criminal laws, including revivers of criminal prosecutions once the statute expires, if limitations expires. But that doesn't apply to civil cases, and the U.S. Supreme Court has expressed strong concern with laws that retroactively alter civil claims, but generally has allowed such laws. States such as Connecticut and Delaware have followed that federal approach, but what matters is Pennsylvania law here, and Pennsylvania has never followed the federal approach. The Commonwealth provides stronger constitutional safeguards for both plaintiffs and defendants. And in fact, as was mentioned earlier, when the Connecticut Supreme Court upheld legislation last year taking the minority approach, it explicitly recognized that Pennsylvania is among the states that retroactively amending a statute of limitations to revive time-barred claims is per se invalid. So what I've seen is due to the constitutional restrictions and the public policy concerns as well, the vast majority of states have rejected some multiple times proposals to revive time-barred claims. There are a handful of exceptions, as those supporting the constitutionality will surely note. But what most states have done to address this very real and very serious concern for children is to adopt a longer statute of limitations. Some have eliminated entirely, but do so in a way that's prospective and does apply to future claims. I appreciate your close consideration of the issue, and I very much welcome your questions.
Thank you very much. Professor, would you have any comments to make?
Are you talking?
Yes.
Please. I agree that the subsection 3 of section 4 of 1947 is a violation of the Remedies Clause. I'm going to truncate my testimony since it's repetitious of what was said previously, but there are one or 2 points I would like to make. The first concerns the characterization of the Lewis case back in 1908. And I think someone characterized it before as an impairment of an existing cause of action. And that the Supreme Court in the Lewis case decided that was a violation of the Remedies Clause, Article 1, Section 11 of the Pennsylvania Constitution. That's not the way the Supreme Court of Pennsylvania characterized the case, though. There was a statute enacted in 1868 that gave railroads a fellow servant's defense if we were talking about a railroad contractee that was injured on the railroad. So from 1868 on, the railroads had that fellow servant defense. A statute was passed in the early 1900s that revoked that defense, and it revoked it retroactively. And the Supreme Court, in that case, reaffirmed the notion that under the Remedies Clause, the legislature could not abrogate an accrued cause of action, and they equate the notion of accrued with vested. So if you're talking about an accrued defense, an accrued cause of action, that's a vested right for purposes of the Remedies Clause. But the Supreme Court in the Lewis case extended the interpretation of the Remedies Clause to include accrued defenses. And the reason I reiterate that is because that part of the Lewis case isn't dictum. When the Lewis case says that the Remedies Clause protects accrued defenses as well as accrued causes of action, that's the holding of the case. And it's not some derelict in the stream of Pennsylvania precedent. This notion that the Remedies Clause protects accrued defenses was reaffirmed 3 times in the last 12 years. Arpoli Canidaris and the 2013 decision in Hospital and Health Systems Association versus Commonwealth of Pennsylvania. So it's recently affirmed long-standing Pennsylvania interpretation, Supreme Court interpretation of the Remedies Clause. There's no counterpart to the Remedies Clause in the federal Constitution, and the way that the Pennsylvania Supreme Court construes it is separate from due process. There is a due process provision in the Pennsylvania Constitution. It's Article 1, Section 9, and it talks about law of the land. Well, the notion of law of the land is the same as due process of law. Okay, Lord Coke used due process of law in his commentary on Magna Carta as a shorthand for law of the land and judgment of the peers. And the Supreme Court of Pennsylvania looks at due process and the Remedies Clause different. And when it comes to the Due Process Clause, it says, look, due process in Article 1, Section 9 of the Constitution is there to protect the citizen against government, to protect the citizen from deprivations of life, liberty, or property by governmental officials. Remedies Clause is different. Remedies Clause, we're offering to private litigants in this Commonwealth an open judicial and a fair judicial system. That's what it's there for. They talk about due course of law when they're talking about the Remedies Clause. They talk about law of the land and due process of law when they're talking about governmental action. And the Supreme Court, as Mr. Silverman has said, and Solicitor General Castor has said, and your own expert has said, due process of law has protected accrued defenses from at least 1908. The idea that a statute of limitations is something different because it's procedural by nature rather than substantive is frankly a red herring. You know, it's not the way the Supreme Court approaches it. It isn't as if they sit back and say it's a priori procedural or it's a priori substantive. They sit back and say, is this going to destroy an accrued vested right in a course of action or defense? Look at the Commonwealth's opinion in the McDonald case. If all it was, if the whole issue revolved around whether the statute of limitations was procedural, then the Commonwealth Court wouldn't have spent all the time it did in that decision asking itself whether the retroactive application of the law would deny the plaintiffs a reasonable opportunity to bring the claim. If it was procedural, that would have ended the case. But what the Commonwealth Court did in the McDonald case was to ask itself, look, is this retroactive reduction of the statute of limitations from 5 to 1 year to challenge eminent domain, is it going to violate a vested right? Is it going to eliminate, in this case, an accrued cause of action? All right? I mean, if a case is dismissed because the statute of limitation has expired and the legislature retroactively revives it, it's destroying an accrued defense. And that's a violation of the Remedies Clause. And it's a clear violation. It's a long-standing violation. Now, the federal system is different. All right? Admittedly, in the Landgraf case in 1994, the Supreme Court said that, well, it's actually dictum in Landgraf. The Supreme Court was dealing with a general rule that if Congress clearly expressed its intent, it could apply a statute retroactively. Now, the reason I said it's technically dictum is because the court in Landgraf found that there wasn't any clear intent in the statute. There was an amendment to Title VII in the Civil Rights Act, and Congress included the damage remedy and was going to apply it retroactively, or at least that was the argument. The Supreme Court says there's no clear intent. All right? So it made its own decision. So technically it's dictum. All right? But dictum means talk. And when the Supreme Court talks, everybody listens. All right? So even dictum in a Supreme Court case is important, but sometimes the Supreme Court goes a little too far. So the year after it decided the Landgraf case, in the case called Plout in 1995, it had to retract a bit. And the Supreme Court said, well, we didn't mean that Congress could, even if it clearly said so, could retroactively revive a case that was finally decided, even when the decision to dismiss the case was based on the statute of limitations, which was involved in the Plout case. What the Supreme Court said was, when a case is dismissed on statute of limitations grounds, it is a dismissal on the merits. And Congress, even though it says it quite explicitly, can't revive it. All right? So the Landgraf discussion perhaps was a little bit, at least the dictum in Landgraf and the footnote that someone read before, was a little bit too broad even for the Supreme Court. But in any event, I think you can fairly say that the Supreme Court's discussion of retroactivity under the Federal Due Process Clause, the Fifth Amendment Due Process Clause in the Landgraf case, its discussion concerning Congress's power is broader than the Remedies Clause. Okay? And there are some states, like Delaware, for example, that view their constitution coextensive with federal due process. And the Supreme Court of Delaware recently said that in the Sheehan case. But if you look at the Delaware Constitution, that's a little different from ours. We've got a separate provision, Article 1, Section 11, Remedies Clause, and a separate provision, Article 1, Section 9, Due Process. And we interpret those provisions differently. In Delaware, the two provisions are combined in one, law of the land and due course of law. And the Supreme Court of Delaware construes that singular provision, Article 1, Section 9, as merely a due process clause. All right? So that may explain why they take a different approach than what we do. But in any event, they're quite free to take that approach. The basic notion when you're talking about cases like Landgraf, etc., is that they're interpretations of the Federal Due Process Clause. The Federal Due Process Clause provides a floor for the states. It doesn't provide a ceiling. It is settled law that the states are free to provide more stringent protections than are afforded by the 14th Amendment. As was stated by one of your witnesses before, it is a centerpiece of federalism. But the federal Constitution, its 14th Amendment, provides the floor, but not a ceiling. And that is precisely what Pennsylvania did in adopting the Remedies Clause to the Constitution. It provided, as it was permitted to do, additional protections. Now, clearly, the objective of remedying childhood sexual abuse is exceptionally laudable. But even the most compelling end cannot be pursued through an unconstitutional means. And in my opinion, and I think the opinion of the Supreme Court going back to at least 1908, is that the Remedies Clause of the Pennsylvania Constitution would render Section 4, Subsection 3 of HB 1947 unconstitutional. Now, I submitted some written testimony in a letter to Chairman Greenleaf on May 27th. It has most of the citations of cases that I referred to in my testimony. And let me thank you very much, not only for the opportunity to testify today, but I've learned a lot, and thank you very much for the opportunity.
Thank you so much. Your material has been included in the packet of information. Thank you so much for being here today. Are there any questions, Senator Rafferty?
Just one quick question. This, Professor and Counsel, this is the one I'm wrestling with over and over again, and I thank you, Professor, for that very thorough and detailed analysis of the remedies clause, and I appreciate it very much. Does the right still vest for the statute of limitations where there may have been, hypothetically speaking, evidence that all along the evidence needed to bring any civil action were concealed and hidden?
Are you asking both of us or just me?
Well, I'll start with you, Professor. How's that?
I don't know is the answer. I think that if you want some indication, the Supreme Court in Dalrymple said we're not going to apply the minority tolling provision. It also said under the circumstances of that case, we're not going to apply the discovery rule. It was a case of repressed recognition, repressed memory. It was a sexual child abuse case. My guess is, based on Dalrymple's refusal to apply the minority tolling provision retroactively, and its refusal to apply the discovery rule in childhood sexual abuse cases, that it probably wouldn't.
Thank you, and I'm sorry I never had you at Temple Law. I'm sorry I never had you when I was at Temple Law.
Oh, count your blessings.
Counselor?
Senator, there may be Pennsylvania case law could consider having some sort of tolling provision during a period of concealment. That would be a matter of law that would go forward prospectively. But I haven't seen in my review of the cases on the constitutionality of changing the statute of limitations any exceptions to that rule of reviving time-barred claims. So that is something that you or the courts could do prospectively, but I don't see any wiggle room in the law that I've reviewed that allows.
Thank you. And I'm not aware, and I could be wrong, but I'm not aware of any cases of that magnitude being brought before the Supreme Court, but I don't know their docket, so thank you very much. Thank you, Mr. Chairman.
Senator?
Thanks, Mr. Chairman. Professors, just generally, there's been some talk about fraud and concealment from my esteemed colleague, Senator Rafferty, but from my understanding, there's a general rule that the statute of limitations doesn't toll until the harm should have been discovered or was discovered. So I think concealment generally is covered because of that general principle.
Yeah, but look at the Dalrymple case because they say the opposite. That's a childhood sexual abuse case.
Thanks, Professor.
And it's a Supreme Court of Pennsylvania case.
Right. So if there is concealment, regardless of this statute,
I'm sorry.
No, I'm sorry, Professor. The statute doesn't toll until the discovery of the harm. So if there was fraud or there was cover-up, then you still wouldn't have the tolling of the statute of limitations until that harm was discovered.
That I don't know. I do know that they won't apply the discovery rule when you're talking about repressed memory.
Thanks. And Mr. Chairman, can I just ask one more question for Professor Mikochek? Professor Mikochek, am I saying that correctly?
It's close enough.
Okay. With my last name, I completely that. Right. But I just want to, for clarity, you were talking about due process, the statute of limitations. I mean, we have these principles in our legal system for predictability and to make sure that the individual is protected from the state. Isn't that correct? I mean, really, it's about protecting the individual from.
Well, that's due process, but we also have the remedies clause, which provides an open judicial forum for the resolution of controversies.
Right, but it's against our principles to go and take a vested right away from an individual.
Yeah, and the vested right means an accrued cause of action or an accrued defense. So when the statute of limitation expires, it's accrued and it's vested.
Okay, thanks, Professor. I appreciate it.
Sure.
Okay, if there are no other questions, thank you so much
Thank you.
for being here today and making your presentation. We do have two other opinions that were submitted to us, one by a retired Third Circuit Court of Appeals Judge Timothy Lewis, and one from Stephen Achel, and John Bassinger, all supporting the testimony in regard to the retroactivity of this legislation. The next witness on our agenda